Anwyl Gyfeillion, noswaith dda. Gadewch I mi ddechrau gan ddiolch I chi am eich gwahoddiad I fod yma yn eich cwmni heno. Diolch am eich croeso mor garedig. Mae'n bleser mawr I mi cyflwyno fy nghyfaill am cydfarnwr, fy mrawd, Patrick Hodge, yr arglwydd Hodge, dirprwy llywydd goruchaf llys y Deyrnas Unedig. Good evening. Thank you for your invitation to join you this evening and for your very warm welcome. And I should say that there are lots of old friends in the audience, and we're joined by many more in an online audience. You're all very welcome. It's a great pleasure to introduce my friend and colleague, my brother, Patrick Hodge, Lord Hodge, Deputy President of the Supreme Court of the United Kingdom. Patrick's a Scotsman, and although he studied history at university in Cambridge and embarked on a career as a civil servant in Scotland, he saw the light. He read law at Edinburgh University and then had a distinguished career in the law at the bar in Scotland and as a Scottish judge before his appointment to the Supreme Court in 2013. In that capacity, he has sat on most of the really important cases decided by the Supreme Court in the last decade, including Miller No. 1, Miller No. 2, and the Rwanda case. And he's made an immense contribution to the jurisprudence of the court. His subject this evening is the Supreme Court 15 years on, continuity and change. And we greatly look forward to that lecture.
Good evening. It is such a great pleasure to be here and a privilege to be here this evening in the Senedd in Cardiff. I'm familiar with the Scottish Parliament, which also is a modern building, and as a proud Scotsman, I would have to admit that the view here is better. You've got a magnificent view from the window behind me. I was slightly sad when I saw the blinds go up because I was enjoying the view as I waited to speak to you this evening. Now, I was not one of the justices who sat in Cardiff in 2019, and so for me it's a particular pleasure to be here now, and I'm very pleased to be here in Wales today and tomorrow, and Lord Reid, the President of our court, will be in Wales over the weekend at various functions and is very much looking forward to meeting judges and the legal community here. And I also extend a welcome to the many students from the law school who I understand have come to visit us this evening. Welcome. The Supreme Court has just had its 15th anniversary, its 15th birthday, and I've had the privilege of being part of it for the last 11 years. Now, my themes this evening, as David has indicated, are of change and continuity between the work of the former Court of Final Appeal, the House of Lords, and the Supreme Court, and also, I hope, to show why this court matters in Wales. Determining the extent of continuity and change in a given historical period is an imprecise art. I used, when I was an undergraduate reading history, to be asked to write essays on continuity and change. And I am sure it's a matter of impression rather than an exercise of measurement. But bear with me if I try to give you my impressions. I'd left practice and joined the bench in Scotland several years before the Supreme Court began its work at the start of the legal year in October 2009. And my memories of appearing in the Apex Court are accordingly of working my way through a labyrinth of corridors in the Palace of Westminster and along a long upstairs corridor parallel to the river, at the end of which was the committee room in which the law lords heard appeals. Vicky and I are used to going along there more recently because that's where Lord Reid and I give evidence every year to the Constitution Committee. And when I get near the committee room, there's a frisson, remembering my nerves as a barrister or advocate, as we'd say in Scotland, appearing there. I also recall appearing in the rather cramped room in Downing Street in which the Judicial Committee of the Privy Council used to hear their appeals. As you know, now we have a separate building on the west side of Parliament Square dedicated to the Supreme Court and the Privy Council, the JCPC, which advertises its excellent cafe by a billboard on the pavement and contains an exhibition centre for the public in the basement. Perhaps more significantly, the court makes a great effort to reach out to the public to explain its work. We live in an age in which people do not accept public authority without question, and the court, like many public institutions, has learnt to explain itself to those members of the public who wish to inquire about our work. In contrast with the secluded location of the Appellate Committee of the House of Lords, the Supreme Court has made itself an outward-looking institution which seeks to explain its constitutional role and the importance of the rule of law to a wider public. We have a website on which much information about the makeup and work of the court, including our judgments and press releases, and it also has information about forthcoming appeals. And the court has, from the outset, broadcast its hearings by live streaming, and recordings of those hearings are available after the event. I have little doubt that the ability of people to watch the court's proceedings contributed to the more temperate response to the court's decision in Gina Miller 1 than was afforded to the divisional court when, as you may recall, a daily newspaper called those judges enemies of the people. People who watched the proceedings could see that they involved a legal debate interpreting a statute in its historical context and not a political discussion or judicial policy making. Now, when a judgment is handed down, the justice will give to camera a short, oral, non-technical presentation of the judgment, and the court also provides press summaries to explain its judgments as soon as they're handed down. They're of use, obviously, to help the press and also let the public know in simple terms what our decisions are about. But I expect the students, if they're having to take on board Supreme Court cases in the summer term shortly before their exams, will find the press summaries rather useful. Our explanatory work isn't confined, of course, to such judicial activity. For many years, justices have reached out to universities and other academic institutions by giving extrajudicial lectures on topics of legal interest. And we also host university mooting competitions in the Supreme Court, which are chaired by a justice and a judicial assistant. Reaching out to students who are still at school, we have operated an Ask the Justice program, which involves a remote meeting between one of the justices and students in their final year at school. The school submits 10 written questions to the court concerning legal and constitutional issues, and in a remote meeting lasting 45 minutes, each student asks his or her question, which the justice then answers. Each of the justices takes part in this program, and we found it a good way of engaging with young students. In the last financial year, 6 of the 13 schools that took part in this program were Welsh schools, and 4 Welsh schools took part in our debate days. Now, in the last financial year, 1.4 million people used the websites of the court and the JCPC. Over 6,000 students participated in tours, and we had over 58,000 visitors. The court also reaches out to new audiences through social media posts describing our work and giving notice of cases and events. And in the last financial year, We had over 293,000 followers on what is now called X, but I still think of as Twitter. We have 17,000 on Instagram and 50,000 on LinkedIn. We also seek to promote diversity and inclusion in the legal profession and to encourage aspiration by people from backgrounds that are disadvantaged or otherwise underrepresented at the bar, by providing internships as part of the bar's Bridging the Bar scheme. And currently we are reaching the end point of a 3-year change program which has redesigned our websites and introduced an online portal through which people will communicate with the court. Litigants and lawyers will lodge documents with the court electronically. Documents will be served by one party on another through the portal, doing away with personal and postal service of documents. The reform will give the court a very useful tool in case management, as there will be an accurate record of the progress of each case from the application of permission to appeal to the conclusion of an appeal if permission is granted. Now, the website and portal are in their final stages of trials, and we hope to launch the portal by the end of the year. As we are a court serving the whole of the United Kingdom, we have sat not only in London, but also here in Cardiff, in Edinburgh, and in Belfast, and more recently in Manchester. Looking over to my CEO, if the budget will allow it, we hope to sit outside London again in the future. Another aspect of the work of the court, which has grown in importance in recent years, is international engagement with other jurisdictions. We host many visits from judges and officials responsible for the administration of justice from many countries. The visitors usually meet justices or officials, depending on what their level of inquiry is, for a discussion and are given a tour of the court building. We have bilateral meetings in person between the justices and the judges of courts of final appeal, principally from European jurisdictions, but also from further afield, including Canada and the United States. And we've held remote bilateral meetings with the High Court of Australia and the Supreme Court of Japan. And Lord Reid visited Japan for a week last year at the invitation of the Chief Justice. Our justices also take part in meetings of international judicial bodies and organizations. And each year, very gifted young lawyers from the United States come to the United Kingdom for a month as interns in the Royal Courts of Justice and the Supreme Court under the Temple Bar and Pegasus Scholar Schemes, and the British judiciary welcomed this year's scholars only last week. In recent years, the Privy Council, the JCPC, has sat in Mauritius, the Bahamas, and the Cayman Islands at the invitation of those jurisdictions, building personal relationships with the judges and officials. We aim to extend the membership of the JCPC to include distinguished retired judges from the jurisdictions which we serve, and we are delighted that Dame Janice Pereira has been appointed a Privy Councillor and will sit in the JCPC in London for a week in December. Now, those have been the principal changes following the move across the square from the Palace of Westminster to the west side of the square. We are seeking and will continue to seek to adapt the court and the Privy Council to the changing needs of the society which we serve. As for the rest of our work, in particular our judicial work in deciding appeals, the leitmotif isn't change, it's continuity. Continuity with the work of the House of Lords rather than change. Now, some commentators, as you'll recall, particularly during the troubled and divisive times when the people's decision in the Brexit referendum was being implemented, have accused the justices of a power grab. Some have suggested that giving the new court the title of Supreme Court has caused a rush of blood to the judicial brain or brains, causing us to seek to emulate the constitutional role of the Supreme Court of the United States. Now, in my experience on the court over the last 11 years, there is no truth in such accusations. On the contrary, it appears to me to be obvious that the judicial work of the justices is marked by continuity with the past. Most of the devolution legislation for Wales, Scotland and Northern Ireland, which gave judges a new role in upholding the boundaries of devolved competences, predated the creation of the Supreme Court, as did much of the jurisprudence concerning them, and so too did the Human Rights Act 1998, which involved judges and involves judges in assessing the proportionality of interferences with fundamental rights. Indeed, as I say, the court inherited developed jurisprudence on these subjects from the House of Lords, not least from the pens of Lord Bingham and of Cornhill and Lord Hope. The judicial task is to clarify the law and to develop the law incrementally and interstitially, adapting it to the changes in our social and commercial life. Now, the media tends to focus on appeals that have political consequences, whether it be the two Gina Miller cases connected with the Brexit process, or the reference on which the Scottish Parliament, on whether the Scottish Parliament had the power to legislate for an independence referendum. And also, I should perhaps add, as Lord Lloyd-Jones has mentioned, the Rwanda case. But the vast majority of our work does not concern such politically sensitive matters. In the last 5 legal years, the Supreme Court has heard in the range of 47 to 74 appeals annually, and the Privy Council has heard in the range of 35 and 62 appeals annually. And the balance of work between the two courts shifts year on year. In the 2023-2024 legal year, the Supreme Court gave 51 judgments and the JCPC gave 39. In that legal year, the principal areas of work on which the Supreme Court issued judgments were public law and human rights, on which there were 8, negligence, on which there were 6, and tax, including VAT, in which there were also 6. Turning to our caseload in the last 15 years, I look first at cases of political significance which have originated here in Wales. The court has heard 3 devolution references from Wales. The first reference concerned the very first bill which was passed by the Welsh legislature, the Local Government Bylaws Wales Bill. This bill removed the Secretary of State's confirmatory powers in relation to certain bylaws, and it was held to be within competence, as this effect was incidental to and consequential upon the primary purpose of the bill. And in that judgment, Lord Hope discussed procedure in devolution references and clarified the respective roles of devolved governments and legislatures. The second one related to the agricultural sector Wales Bill. The bill was held to be within competence as it related to agriculture. In context, the court interpreted the word agriculture as referring not solely to the cultivation of the soil or the rearing of livestock, but as designating the industry or economic activity of agriculture in all its aspects. Looking at the consultation process that led to the bill and the legal and practical effects of the bill, the court held that it was clear that the purpose and effect of the bill should be classified as relating to the devolved matter of agriculture. In the third reference, the recovery of medical costs for asbestos diseases Wales Bill, the bill was held to be outside the competence of the legislature. There were 2 relevant provisions in that bill which came up against the limits of competence. Section 2 of the bill made persons by whom or on whose behalf compensation payments were made to victims of asbestos-related diseases liable to the Welsh ministers for the cost of NHS services provided to those victims. And the other provision, Section 14, extended the scope of the insurance policies, the compensators' liability insurance policies to cover the sums that they would have to pay under their Section 2, their new liability under Section 2. Now, the court unanimously held that the Welsh legislature did not have legislative competence to enact the bill in that form. The leading judgment was written by Lord Mance, with whom Lord Neuberger and I agreed. It held first that the bill was not sufficiently related to the organisation and funding of the NHS, which was a devolved competence. The charges were imposed on compensators and their insurers rather than on the patients, and they lacked direct and close connection with the provision of NHS services. In effect, the bill sought to impose new tortious liabilities on third parties to pay for Welsh NHS services. Secondly, the bill infringed the rights of compensators and their insurers under Article 1 of Protocol Number 1 of the European Convention, as the retrospective effect of the bill required special justification, which was absent, the retrospection being the rewriting of the insurance policies. The involvement of Welsh interests in constitutionally important cases hasn't been confined to those three references. The First Minister or the Counsel General has intervened in several important hearings in the Supreme Court. Those interventions were made in both of the Gina Miller appeals, the first of which was significant to devolution settlements in holding that the Sewell Convention was not justiciable. And there were also interventions by the Counsel General in three Scottish cases: AXA General Insurance Limited against the Lord Advocate, the UK withdrawal from the European Union Legal Continuity Scotland Bill, it's a bit of a mouthful, and thirdly, the UNCRC Incorporation Bill reference. But, as I've said, the vast bulk of the court's work doesn't concern cases of constitutional significance. Now, in a short address to you tonight, I can't do justice to the range of work which has been undertaken in the last 15 years in the 1,112 cases that we've heard in the court during that time. So I will instead draw on certain themes with which we see the court clarifying or developing the common law of contract and tort, and I will point out important cases relating to Wales which fall within the scope of those themes and have contributed to our jurisprudence. Commercial work forms a significant part of the court's workload. One of the areas in which the court has been engaged is the restatement of the approach to the interpretation of contracts. There has been a broad continuity in the approach of English law to the interpretation of contracts since the 1970s, when two judgments of the House of Lords set out the ground rules. Then, in a momentous judgment in Investors' Compensation Scheme case in 1998, Lord Hoffman set out an approach to the interpretation of contracts which ignited a debate in legal circles on the scope for the court to use its perception of business common sense when considering the meaning of words which the parties used in their contract. In three cases since then, the Supreme Court has revisited the interpretation of contracts in an attempt to clarify, at a high level of generality, the correct approach to contractual interpretation. In the first, Rainy Sky and Cookmin Bank, Lord Clark, giving the unanimous judgment of the court, explained that there were two possible interpretations, that where there were two possible interpretations to a provision, it was generally appropriate to adopt the construction which was most consistent with business common sense, drawing on Investors' Compensation Scheme. In his lead judgment in Arnold and Britain, Lord Neuberger set out an approach which re-emphasized the need to have close regard to the wording of the contract. He stated that when interpreting a written contract, the court must identify the intention of the parties by referring to what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to be. using would understood to be using the language in the contract to mean, focusing on the meaning of the relevant words in their factual and commercial context. Now, in large measure, that was not saying anything that wasn't said in Investors' Compensation Scheme, and nor was Lord Clark saying anything that wasn't said in Investor Compensation Scheme, but you can see a tension between the two. Thereafter, we faced another appeal on the general approach to the interpretation of contracts, and Lord Newburger asked me to write a judgment which might put an end to the constant revisiting of the issue. The judgment, Wood and Capita Insurance Services Limited, didn't make new law, but sought to show that there was no inconsistency between Rainy Sky on the one hand and Arnold on the other, emphasizing that there were horses for courses in contractual interpretation, and that the degree of respect which the court gives to the words of a contract will depend on the nature of the contract and the circumstances in which it was entered into. As I stated, no interpretive technique has exclusive possession in the field of contractual interpretation. Whether that puts the argument to bed, only time will tell. We also revisited other areas in the field of contract. In Cavendish Square against El Makdessi, Lord Newburger and Lord Sumption gave the lead judgment, with which Lord Carnwath agreed. Lord Mance, Lord Toulson and I also gave judgments, and Lord Clark gave a short judgment, agreeing with different aspects of his colleague's judgment. Lord Toulson, in his partly dissenting judgment, you probably guess what he's going to say, not unfairly described the judgments as being exceedingly long. The appellants, Cavendish, argued as their primary submission that the court should abolish the rule that they don't enforce penalty clauses. In the alternative, Cavendish argued that the rule should be altered so that it didn't apply to commercial transactions in which the contracting parties are of equal bargaining power and each acted on skilled advice. Now, the court rejected both of those submissions, as it did the submission on behalf of the respondent, Mr. El Makdessi, who wanted the rule against penalties to be extended to circumstances which didn't involve a breach of contract. The court applying the rule asks whether the contractually stipulated remedy for a breach of contract is exorbitant or unconscionable when regard is had to the innocent party's interest in the performance of the contract. In that case, neither of the contractual terms which the court addressed offended the rule against penalties. Now, the correct approach to the law on illegality of contract, for those studying law, they'll be familiar with the Latin maxim ex turpe causa non orator actio. This doctrine of illegality has caused the court greater difficulty, and it took several tries to obtain an authoritative ruling on the question. This perhaps demonstrates the court at work. In those cases, some of the justices advocated a clear-cut rule which renders a contract unenforceable at the instance of the party who has to found on the illegal or immoral act in making its claim, while others favored a multifactorial approach which has regard to various considerations of public policy which may pool in different directions. And this, of course, gives the court greater scope to achieve a just result. Thus, the tension is between those who like a hard and fast rule and those who want elbow room to reach a just result. In Hunga and Allen, a panel of 5 justices addressed a claim for the statutory tort of unlawful discrimination by a young illegal immigrant whom Mrs. Allen employed unpaid to look after her children, physically abused, and then dismissed and evicted forcibly from her home. Her claim failed before the Court of Appeal because Miss Hunga's immigration offences were inextricably linked to her contract of employment, which was illegal. Lord Wilson, giving the leading judgment, rejected this approach, holding that the defence of illegality rested on a foundation of public policy, and it was therefore necessary to ask first what aspect of public policy founds the defence, and secondly, whether there's another aspect of public policy to which the defence would run counter. The concern to uphold the integrity of the legal system by not enforcing an illegal contract was, in his view, totally outweighed by the fact that Miss Hunger was the victim of trafficking at the hands of the Allen family. Shortly thereafter, in Les Laboratoires Servier against and Apotex Incorporated, a different panel of 5 justices addressed the question of what amounted to turpitude which could support the defence of illegality in the context of a patent dispute. The panel unanimously upheld that the infringement of foreign patent rights did not constitute the relevant turpitude for the purposes of the defence. But as to why, there was disagreement. Lord Sumption, in the lead judgment, rejected any reliance on questions of public conscience or the balancing of various considerations when deciding whether the defence of illegality was available. He argued that the decision of the House of Lords in Tinsley and Milligan was a binding statement of an established legal rule, notwithstanding that it could, as he recognised, have draconian consequences. Lord Toulson concurred in the result, but indicated a sympathy for the approach taken in Hunger and suggested it might be necessary to reassess Tinsley and Milligan in the light of the criticisms of that decision by, among others, the Law Commission. The question arose again in a 7-justice case. We moved from 5 justices to 7 in an appeal Jativia and Bilter, Jativia SA against Bilter UK, which concerned a VAT carousel fraud in which the panel was divided as to the correct approach. Lord Sumption adhered to the view that the defence of illegality was a rule of law, rejecting the wider approach to public policy, which Lord Toulson advocated and I supported. The other justices reasoned, perhaps sensibly, that the case was not appropriate for deciding on a general basis the proper approach to the defence of illegality, but suggested that the law on illegality be reviewed by the court at a suitable time. Lord Neuberger thereafter convened a 9-justice panel in the case of Patel and Mirza to resolve the issue authoritatively. I well remember the conference of the justices which followed the hearing, as it's the only case in which I recall frayed tempers and angry words being exchanged based on strongly held views as to the correct approach. Lord Toulson's approach prevailed by a majority of 5 to 3, and the President, Lord Neuberger, also supporting Lord Toulson's approach as reliable guidance. In other areas of contract law, the court has given guidance on the implication of terms into a contract, and similarly the justices in their role as judges of the Privy Council have ruled on the availability of the defence of contributory negligence against a claim in contract, and have clarified the law on remoteness of damage. Turning from contract to the law of tort, the Supreme Court has made several important decisions which have, I hope, brought increasing clarity to our law. A recurrent theme has been the boundaries of liability of public authorities for omissions, that is to say, for failing to intervene to prevent injury to other people or damage to their property. And one of the leading cases is the Welsh appeal in Michael and the Chief Constable of South Wales Police. That case concerned an error by a 999 call handler and the failure of South Wales Police to respond effectively to a 999 call by a woman who was the victim of serious physical domestic abuse. Immediately after a second 999 call, the police responded very promptly, but by the time they got there, tragically, she had been brutally attacked and stabbed to death by her ex-boyfriend, who later pleaded guilty to murder. A 7-justice panel heard the appeal and by a majority of 5-2 upheld the decision of the Court of Appeal to strike out the claim in negligence against the police. Lord Toulson gave the majority judgment in which he surveyed the relevant case law not only domestically but also abroad. The duty of police in public law to protect members of the public from harm caused by third parties didn't give rise to a parallel duty of care in negligence. In that case, an alternative claim under Article 2 of the European Convention was allowed to go to trial. The court has considered the liability of police further in Robinson and Chief Constable West Yorkshire Police. In that case, a vulnerable woman was injured when the police attempted to arrest a suspected drug dealer in a busy street in Huddersfield. There was a struggle which resulted in the police and the man being arrested falling on top of the, I suppose I might have to say elderly woman, but she was of my age. The court analysed the case not as a claim for an omission, but as a traditional Donoghue and Stevenson claim for the foreseeable consequences of a positive act. That was the decision of the police to make the arrest in the circumstances in that street when they did. The judgment is important also for its limiting of the role of what the students will be very familiar with, the Caparo test, to novel situations, and removing also misunderstandings as to whether the police have immunity from suit in negligence. More recently, the police have returned to the court has returned to the question of liability for omissions in a case Tyndall and Chief Constable of Thames Valley Police, a case concerning a fatal road traffic accident as a result of black ice, and will be handing down a judgment in that appeal shortly. In 2 Scottish appeals on medical negligence claims, the court addressed the circumstances in which a doctor would incur liability for failing to take a patient's informed consent. The former appeal, Montgomery against Lanarkshire Health Board, is particularly significant as the court performed its task of updating the law to reflect changing social attitudes in relation to individual autonomy. They did so by replacing the Bolam test, which gives a degree of discretion to the medical profession, with a test which focuses on what a reasonable patient would wish to know when considering whether to consent to a significant medical intervention. In a later appeal, McCulloch against the Forth Valley Health Board, the court rejected an attempt to impose further liability on doctors in relation to the judgments which they have to make as to what alternative treatments they must inform the patients about when asking for informed consent. Now, we've had a string of cases on vicarious liability concerning how far, among other things, the law can be extended beyond the employment relationship. And this again includes an important case which came from Wales, and that is Cox and the Ministry of Justice. Now, in that case, the claimant was the catering manager of HM Prison Swansea, whose duties included supervising prisoners who worked in the kitchen alongside civilian catering staff. In that case, a prisoner negligently dropped a sack of rice onto Mrs. Cox's back, causing her injury. Now, the court upheld the order of the Court of Appeal and found the defendant liable for the prisoner's negligence. Lord Reid, in the lead judgment, explained the significance of the 5 factors identified in the earlier Christian Brothers case as the test for imposing such liability outside employment relationships, and commented on the relative weight of those factors in that assessment. So if you're doing work on vicarious liability, I do advise you to look at that Welsh case. It gives a lot of guidance. Turning to the tort of nuisance, the court gave general guidance on the tort in Coventry and Lawrence. More recently, the court wrestled with the question whether the owners of the Tate Modern Gallery in London could be liable to neighbouring residents of flats which had walls made substantially of glass, as a result of their being overlooked by a public viewing platform in the gallery, and that's the case of Fern and the Board of Trustees of the Tate Gallery. The court was divided 3-2 on the issue, the majority holding that the inviting of the public to admire the view from the viewing platform was not a common and ordinary use of the land, and that constant visual intrusion of that nature amounted to a nuisance. The minority didn't accept that distinction between ordinary and extraordinary use of the land, but sought to answer the question by reference to principles of reciprocity and compromise, and an objective standard of reasonableness having regard to the nature of the locality. I suppose what you might summarize it as, do you buy houses with glass walls in the center of a city? Anyway, last year, the court addressed the question whether an offshore oil spill was a one-off event or a continuing nuisance. And we've also discussed the relationship between the common law tort of nuisance and the legislation governing the water industry in an important case which we heard in Manchester last year, Manchester Ship Canal and United Utilities. Wales has also contributed to our law of nuisance. In Davis and Bridgend County Borough Council, the court addressed the question of causation in nuisance. The case concerned the encroachment on land by Japanese knotweed. Mr. Davis purchased his land in 2004. At some date well before then, the knotweed had spread from land owned by the council. By 2013, the council knew or ought to have been aware from publicly available information that knotweed posed a risk of damage and loss of immunity. The council failed to implement a reasonable and effective treatment program on its land until 2018. Mr. Davies sued the council in nuisance. The court unanimously allowed the council's appeal, overturning the Court of Appeal's award of damage for a residual diminution in the value of Mr. Davies' land. The court reasserted established principles of causation, holding that the claimant had to establish that the council's breach of duty in fact caused the loss suffered. It applied the but-for test to eliminate irrelevant causative factors. As the diminution in value of his land occurred long before the council were in breach of their duty, that breach of duty didn't cause the loss, and the claimant wasn't entitled to an award of damages. Now, in the time available, I have not covered appeals in public law, criminal law, taxation, company law and insolvency, shipping law, and public international law, among others, which have occupied the court over the last 15 years. Nor have I discussed other cases which address legislation from the Senedd. But I hope that I have given you a flavour of our work in explaining and developing the common law, and have mentioned significant Welsh cases which have contributed to our jurisprudence. In conclusion, in its 15 years, the court has sought and seeks to provide a service to the whole of the United Kingdom. This service is the social service of resolving private and public disputes in a reasoned manner by the application of law, rather than allowing visceral reactions and violence to determine outcomes. It's promoting coherence in the common law. It's developing the common law to keep it up to date and to accommodate the needs of our changing society. In constitutional law and public law, the court is an important part of our constitutional structure of checks and balances, which is a structure critical for the health of a democratic society. Those are the functions of the judicial branch of the state. Returning to my opening theme of continuity and change, we have seen great changes in the way in which the court reaches out both domestically and internationally, but we have seen continuity in the judicial function. Long may that continue. Thank you.
Over the last 20 years or so, coinciding with the period of political devolution, we've seen important changes in the administration of justice in Wales, intended to ensure that it's responsive to the needs of the people of Wales. And these have played a major part in establishing the distinctive identity of Wales within the legal system of England and Wales. In particular, the coming of devolution meant that legal challenges to the decisions of the newly created institutions and to other public bodies in Wales required to be brought, heard and decided in Wales. And Wales took full advantage of the general reform of public law hearings in England and Wales, which occurred in 2009, with the result that the administrative court now sits throughout Wales, as required, deciding issues of public law. Both the civil and criminal divisions of the Court of Appeal sit frequently in Wales, the only place where they sit regularly outside London. Wales is served by a professional judiciary with a strong Welsh identity, and every effort has been made to facilitate and promote the use of the Welsh language in the courts in Wales. Now, a significant milestone along this road was the inaugural sitting in Wales of the Supreme Court of the United Kingdom in July of 2019. The Supreme Court is, as we've heard, the final court of appeal for all three jurisdictions within the United Kingdom. It also plays an important constitutional role in ruling on the competence of the devolved legislatures. The Supreme Court normally sits in its home in Parliament Square in London. It had on one previous occasion sat in Edinburgh and once in Belfast. On this occasion, we sat in the Senedd in Cardiff Bay, just on the other side of the building in T. Howell. The court comprised our then President, Lady Hale, the Deputy President, Lord Reid, Lord Sales, Lord Thomas of Cwmgyrdd, and myself. We were given a wonderful welcome by the staff in the Senedd, some of whom are present this evening. May I welcome you, and once again, thank you for the wonderful welcome you gave us on that occasion. The intention was that we should function as a Supreme Court in Cardiff, just as we would if we were sitting in Parliament Square in London. The proceedings were live streamed, as are all our proceedings. We heard 4 appeals during the week, we handed down a number of judgments, and we made a reference to the Court of Justice of the European Union. In those days, the United Kingdom was still a member of the European Union. Extensive use was made of the Welsh language in court, including the only reference ever made to the Court of Justice of the European Union in Luxembourg, in both English and in Welsh. When the response came from Luxembourg, it was, I regret to say, only in English. As it happened, none of the appeals that week concerned a Welsh devolution issue or legislation made by the Senedd. One of the cases had a Welsh connection in that it concerned miners' compensation, and the claimant was a Welshman resident in Wales. The applicable law in that case was the law of England and Wales. Another case was a close miss. It concerned planning permission for a wind farm in the Forest of Dean, just across the border. I explained at the time to our President, Lady Hale, that the reason there were so comparatively few appeals from Wales was because the judges in Wales were so good that they got it right the first time. She was, I'm sorry to say, skeptical about this explanation. Nevertheless, the decision that we should sit in Wales was an appropriate recognition of the changing legal status of Wales. Since the COVID pandemic, the Supreme Court has sat outside London on only one occasion, in Manchester last year to hear an appeal concerning the Manchester Ship Canal, when 7 of us sat in a very important appeal to which Patrick has just referred. However, I very much hope that there will emerge a settled pattern of the Supreme Court sitting in the capital cities of all of the nations of the United Kingdom, and that it will soon be able to sit in Cardiff once again. On a personal note, I can tell you that the sitting of the Supreme Court in Wales was, for me, one of the high points of my career in the law. As a Welshman born and brought up in Pontypridd, the whole week was a highly emotional experience. The most emotional point probably was in a wonderful dinner given by the Bar and the Law Society, when the assembled choir sang both of the two great tunes that my hometown Pontypridd has given to the world, Henlad van Hadau and Cwm Rhondda. I was bursting with pride to be able to play a part in the court sitting for the first time in Wales. During one of the many social events which accompanied the sitting in Cardiff, and they were many and they were glorious, I can tell you, a beautiful document was presented to the Supreme Court by the Legal Wales Foundation. On it is inscribed the following statement taken from the laws of Hywel Dda as to the role of a judge. Brawdwr a dylu grandaw yn llwyr, cadw yn gofawdur, dysgu yn graff, datganu yn war, barnu yn trigarawc. A judge is to listen fully, keep in memory, learn acutely, pronounce courteously, and judge mercifully. The document now hangs in pride of place outside Court 2 in the Supreme Court in Parliament Square. To my mind, these are words of great wisdom and humanity coming down to us over 1,000 years, and an inspiring statement of what judges in any age should be trying to achieve. I can promise you that it is a statement to which Lord Hodge and I and all of our colleagues in the Supreme Court will continue to aspire. Diolch unwaith eto am eich croeso mor goredig heno. Diolch yn fawr.